You are a danger to my community and to put you in jail because you refuse to comply with bond conditions. And I've given you over and over. I appreciate your tenacity and I love that you're defending zealously, but I can't let him go. It would be enabling this behavior and telling him it's okay for you to do what you're doing. And it's not. It's not okay to sit there and stomp on someone's head.
I mean, we're talking about a misdemeanor assault between children, not a.
Well, I don't know that. I mean, you're putting in stuff that I have no idea
The state
about.
alleged a misdemeanor assault. They didn't allege an aggravated assault, which they could have, and they did not. They alleged a misdemeanor assault.
Doesn't make me feel better.
Well, I mean, the state says, alleges that there's all this injury. We can see what the injuries were. You see the plaintiff witness in a picture. She's smiling.
Did she go to the
talking
hospital?
To the police. No, she didn't go to the hospital, Judge.
I don't know.
I've read everything. She hasn't gone to the hospital. She has a swollen eye is what she has.
Judge, I don't believe, I mean, her hair was also ripped out, Judge, based on what we see in the four corners of the dims. We haven't done.
I don't know. I mean, there's a lot of people who wear different types of hair.
Sure.
So,
But just going off the dims, we have her hair being ripped out and being stopped. So
and to your question, not hospitalized, Judge.
so here's what I'll do.
Judge, just if I may add, even in the first AFM, Judge, the complainant has gone back to the home at least once, to my knowledge, based on my communications with the complainants on that case. The defendant has gone back to the grandmother's homes, contrary to the bond conditions and the no contact orders in that case. He's repeatedly, time and time again, violated his bond conditions, and now so we would be opposed to anything less than $1,000.
Yeah, I know. So what I was going to, his bond on the first assault is it's $1,500. I'll do 2501 on that. Okay, I'll only raise it at $1,000. On the new case, what do you think?
In charge with a misdemeanor. I mean, if the state felt so vigorously about this case, then they would have filed it in district court. I mean, this is a misdemeanor assault between.
I think there's no way this would have been gone upstairs.
I agree, and which is why I think a personal bond could be adequate in light of the fact that he would be given a surety bond on his previous case. He doesn't have much of anything. If anything, that keeps him in jail until we get to trial, because that would be a case that we would set.
All right, Mr. Brooker, I'll set the new one. I'll set it at $500. You're going in today, but I hope you get it. I mean, we're not going to stand for this. You got to pay the piper. And I don't know if it's dealing with the school now will get you to wake up and realize that you can't do what you're doing, but that's it. I've literally bent over backwards not to put you in jail, Mr. Smith, literally bent over backwards. How many chances have we, goes with you. Okay, Mr. Smith, good luck.